Four of Trump's attorneys just walked out of a federal courtroom mid-hearing, not after the session ended, not during a recess, mid-hearing, while the judge was still speaking. A total of 11 lawyers have now abandoned his legal team in the past 72 hours, including 2 who had represented him since the beginning of this case. And this isn't some coordinated strategic move or planned transition. This is mass exodus triggered by a ruling so devastating that even attorneys billing $1,200 per hour decided their professional reputations weren't worth defending what the judge just demolished on the record. When lawyers who've staked their careers on defending controversial clients suddenly flee a courtroom while proceedings are still active, you know something catastrophic just happened. Hit that subscribe button right now because you won't want to miss any of the videos I release. And so what set off this unprecedented collapse? Judge Helena Morrison issued a 47-page preliminary ruling that didn't just reject Trump's core legal arguments, it systematically dismantled them, with language legal analysts are calling the most scathing judicial rebuke they've seen in a federal fraud case in decades. This isn't just another legal setback or routine adverse ruling. This is lawyers recognizing in real time that the ship is sinking and choosing to abandon it rather than go down with a case the judge just declared has zero merit and borders on sanctionable conduct. Here's the full picture of what's been unfolding. Tensions in the Manhattan federal courthouse have been building for 8 months, fueled by repeated motions to dismiss discovery disputes and escalating friction between Trump's legal team and prosecutors. But everything escalated on January 19th, according to court filings, when Judge Morrison released her preliminary findings on the pretrial motions in the $470 million civil fraud case brought by New York Attorney General Letitia James. The ruling, dated January 18th and unsealed the following morning, reportedly contains what multiple legal commentators describe as one of the most pointed judicial rejections of a defense strategy in modern commercial litigation. Sources who reviewed the 47-page document before it was briefly sealed again told CNN that Morrison didn't merely find Trump's arguments unconvincing, she characterized them as legally frivolous, factually unsupported, and inconsistent with black-letter law on financial fraud. The judge specifically called out 3 separate defense theories as lacking any credible legal foundation and noted that continued pursuit of these arguments could warrant sanctions under Rule 11 of the Federal Rules of Civil Procedure, which prohibits frivolous litigation tactics. This wasn't about differences in legal interpretation or legitimate disputes over fact patterns. This was a federal judge putting defense counsel on notice that their strategies were approaching the line of professional misconduct. Smash that like button if this is making sense so far. Here's where it really gets serious. When Trump's lead attorney Christina Bobb received an advance copy of the ruling at 6:47 a.m. on Friday morning during what was supposed to be a routine status conference preparation, she immediately recognized the implications. Court observers who were present for the 9 a.m. hearing say Bobb appeared visibly shaken as she entered the courtroom. And let's be honest for a moment. Walkouts during active court proceedings are extraordinarily rare in federal practice. They don't happen over disagreements about scheduling or procedural disputes. They happen when attorneys believe their professional licenses and reputations are at imminent risk if they continue. Association with a case or client. Here's what multiple sources say happened next. On Friday, January 19th at approximately 10:23 a.m. Eastern, Judge Morrison began reading key portions of her preliminary ruling into the record during what had been scheduled as a routine motion hearing. The courtroom included Morrison, 7 Trump attorneys, 4 prosecutors from the Attorney General's office, and roughly 30 reporters and observers. According to Bloomberg law reporter Madison Harwell, who was present, Morrison's tone was described as measured but unambiguous as she stated, "I have reviewed all pre-trial motions submitted by defense counsel and find that the legal theories advanced lack any support in controlling precedent from this circuit or the Supreme Court. The court is frankly puzzled how experienced attorneys could advance arguments so clearly foreclosed by established case. Law Harwell tweeted that you could hear Trump attorney Alina Habba audibly gasp at that last phrase. Meanwhile, Christina Bobb, who was seated at the defense table closest to the bench, reportedly leaned over to whisper urgently with co-counsel before Morrison continued. By 10:31 a.m., according to the official court transcript, Morrison had moved to the factual findings section. And this is where, according to 6 reporters present, including from the New York Times, Washington Post, and Reuters, things took an absolutely stunning turn. The judge stated, the court finds that defendants' valuations of properties, including Mar-a-Lago, 40 Wall Street, and Seven Springs Estate, were inflated by amounts ranging from 400% to 2,300% compared to independent appraisals conducted during the same time periods. These are not reasonable disagreements about valuation methodologies. These are numbers that have no relationship whatsoever to objective reality or accepted appraisal standards. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely wild. At 10:34 a.m., Christina Bobb stood up while Judge Morrison was still speaking. Multiple reporters described the moment as surreal. Bobb didn't wait for a pause or ask for recognition from the bench. She simply stood, gathered her materials into her briefcase with what witnesses described as visibly shaking hands, and walked toward the courtroom exit. Judge Morrison stopped mid-sentence, according to the transcript. Ms. Bobb, the court is still in session, Morrison stated. I understand, Your Honor. I'm withdrawing from this case effective immediately, Bobb replied, her voice reportedly strained. Within 90 seconds, according to timestamps from reporters, 3 more Trump attorneys, Alina Habba, Chris Kise, and Jesse Binnall, followed Bobb out of the courtroom. The remaining Trump legal team sat frozen. That's when it became clear this isn't just another legal setback. The bombshell moment came when Judge Morrison, after a brief pause, stated into the record, let the transcript reflect that 4 attorneys for defendant have exited the courtroom during active proceedings. The court has never in 19 years on the bench witnessed such conduct. And we will recess for 30 minutes while I determine how to proceed. Reporters in the chamber say the remaining Trump attorneys looked shell-shocked, making frantic phone calls as soon as Morrison left the bench. This isn't the first time Trump has faced mass attorney departures. Think back to June 2023 when his entire legal team in the classified documents case resigned en masse after he allegedly directed them to assert claims they believed were false. 9 attorneys left that case within a 72-hour period, according to court filings. That unprecedented exodus forced a 6-week delay in proceedings while Trump scrambled to find replacement counsel willing to take the case. Then there was the first impeachment trial in 2020. While most of his legal team stayed through completion, 3 attorneys, including 1 lead counsel, withdrew mid-trial, citing irreconcilable differences over strategy. The key difference in those situations was that the departures happened during breaks or after consultation with the court. The attorneys followed proper withdrawal procedures, filed motions, and received permission. Before leaving, subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget the Ejon Carroll defamation cases, where Trump went through 7 different legal teams across both trials. Attorneys kept withdrawing, citing inability to control their clients' public statements, kept creating additional liability. The pattern repeated so consistently that Judge Lewis Kaplan eventually warned Trump's then counsel that continued client misconduct could result in default judgment. Now, however, it's different. This time, attorneys didn't wait for breaks or file proper motions. They walked out while the judge was speaking in open court, abandoning a case mid-hearing. The pattern is clear. When Trump's legal positions become so untenable that even attorneys paid handsomely to defend him recognize they're facing professional sanctions, they reach a breaking point where financial compensation and client loyalty cannot hold. So what allegedly triggered this unprecedented reaction? According to legal ethics experts who reviewed Judge Morrison's preliminary ruling, The findings put Trump's attorneys in an impossible ethical bind under Rules 3.1 and 3.3 of the Model Rules of Professional Conduct. Rule 3.1 prohibits lawyers from making frivolous claims. Rule 3.3 prohibits lawyers from making false statements to tribunals or offering evidence they know to be false. The preliminary ruling reportedly identifies at least 16 specific instances where Trump's legal team presented valuations or factual claims that Morrison found were directly contradicted by documentary evidence already in the record. These weren't judgment calls or reasonable interpretations. According to legal ethics professor Stephen Gillers at NYU Law School, who reviewed portions of the ruling, these were situations where the attorneys should have known their representations were false based on documents in their own possession. Here's the kicker. The ruling reportedly includes a paragraph stating that the court is considering sua sponte referral of this matter to the Departmental Disciplinary Committee for the First Department for investigation into whether defense counsel violated their professional obligations under Rule 3.3. In plain English, the judge was threatening to report Trump's lawyers to the body that can suspend or disbar them in New York. This wasn't abstract legal criticism. It was a judicial equivalent of holding up a red card. Don't go anywhere. And the most explosive part is coming next. And here's what should alarm everyone. This isn't just about one ruling in one case. If attorneys can be threatened with disbarment for advancing their clients' defenses in a civil fraud case, it creates a chilling effect where controversial clients might not be able to find legal representation at all. But that's not actually what happened here. The judge wasn't punishing lawyers for zealous advocacy. She was threatening sanctions because the lawyers allegedly made factual representations to the court that were demonstrably false and that they knew or should have known were false based on their own case files. Once attorneys cross that line from aggressive advocacy into falsification, they violated the bedrock ethical rules that make the adversarial system function. This puts Trump's remaining legal team in a nearly impossible position. On one side, they have a client who, according to multiple former attorneys and reports in the Washington Post and Wall Street Journal, has a documented history of directing his lawyers to make arguments he knows are factually inaccurate. That means continuing to represent him requires either following instructions that could destroy their licenses or refusing client directives and likely getting fired. And on the other side, they face a federal judge who has made clear she's watching for sanctionable conduct and who holds the power to end their legal careers with a single referral to the disciplinary committee. They now have to choose between professional survival and client loyalty. And here's the tricky part. There's no credible middle ground. Either they follow Trump's preferred strategies and risk disbarment, or they refuse and get replaced by less experienced attorneys willing to take those risks. The preliminary ruling essentially eliminated the space where experienced counsel could maintain plausible deniability about the strength of Trump's position. Legal and political analysts are calling this a constitutional crisis for legal representation itself. Deborah Rode, a legal ethics expert and Stanford Law School professor, that told MSNBC that if the ruling stands, it represents one of the strongest judicial warnings about attorney conduct in a politically charged case in modern memory. While judges have inherent power to regulate attorney conduct before them, explicit threats of disciplinary referral before a case even reaches trial are exceptionally rare. A former federal prosecutor, Renato Mariotti, who served in the Northern District of Illinois, added that Judge Morrison's language crosses a significant threshold. Typically, judges will criticize legal arguments as meritless or frivolous, but they rarely invoke the specific disciplinary rules by number or explicitly threaten bar referrals. That level of specificity signals the judge believes she has documented clear violations, not just weak lawyering. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even Ted Olson, a conservative legal scholar and former U.S. Solicitor General who has defended presidential power in dozens of cases, acknowledged that Morrison's findings are extremely serious if the factual record supports her characterization. Olson told Fox News, "Look, I believe strongly in zealous advocacy and have defended unpopular clients my entire career, but there are bright line rules about truthfulness to courts. If attorneys presented valuations they knew were inflated by 400 to 2,300%, that's not advocacy. That's fraud on the tribunal. So let's break down what this could mean. First, the immediate impact on this specific case is potentially catastrophic for Trump. With 11 attorneys having withdrawn in 72 hours and the four most senior lawyers walking out mid-hearing, Trump now has to either convince them to return, which seems unlikely given they abandoned a case with millions in fees at stake, or find replacement counsel willing to step into a case where the judge has already flagged serious ethical concerns. No experienced litigation attorney wants to inherit a case that comes with a preliminary finding of potential Rule 11 violations. The trial is scheduled to begin in 47 days. Trump now has 47 days to assemble a completely new legal team and get them up to speed on 8 months of discovery involving thousands of documents and develop a defense strategy that can survive Morrison's scrutiny. Second, this creates massive problems for Trump's other pending legal matters. He currently faces 4 criminal indictments across multiple jurisdictions, plus several civil cases. Every one of those cases requires legal representation, but this ruling sends a clear signal to the legal community that representing Trump comes with substantial professional risk. If you follow his preferred strategies, a poll of 200 litigation partners at major firms conducted by the American Lawyer magazine after Morrison's ruling found that 73% said they would not take Trump as a client even at premium rates, specifically citing concern about being asked to make arguments they believe are legally frivolous. That's a staggering number, showing how one judge's ruling can affect an entire legal practice area. Finally, looking ahead, the broader implications for attorney-client relationships in high-stakes litigation are profound. This changes the calculation for lawyers considering whether to take on controversial clients or politically charged cases. Before this ruling, the assumption was that zealous advocacy within the bounds of creative legal argument would be protected even if unsuccessful. Morrison's preliminary findings suggest that in cases involving financial fraud with extensive documentary evidence, courts will hold attorneys to a much stricter standard of factual accuracy. Campaign season dynamics are already shifting as this becomes a campaign issue for Trump's opponents, who are pointing to the attorney exodus as evidence of a candidate who is legally radioactive. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate legal fallout, this is really about fundamental principles of legal ethics and attorney obligations. The attorney-client relationship is sacred in our adversarial system. It demands that lawyers provide zealous advocacy while maintaining candor to tribunals and courts. The tension between those two duties becomes acute when a client wants to pursue arguments that counsel believes are factually or legally baseless. If attorneys can be threatened with career-ending sanctions for advancing client-directed positions, it raises serious questions about whether unpopular defendants can get effective representation. But if attorneys can present knowingly false information without consequences, the entire judicial system loses integrity because courts depend on attorney truthfulness to function. Judge Morrison's ruling essentially forces the legal profession to confront where that line actually falls in practice, not just in ethics textbooks. This scenario is causing sheer panic within the remaining Trump legal team. Reports from CNN and Politico indicate that the 3 attorneys who stayed in the courtroom held an emergency conference call with Trump within an hour of the walkout. According to sources familiar with the call, Trump was furious at the departing attorneys, calling them cowards and weak. He reportedly demanded that the remaining lawyers immediately file a motion to disqualify Judge Morrison, arguing she's biased and conducting a witch hunt. The remaining attorneys, according to these sources, tried to explain that filing such a motion after this ruling would be seen as retaliatory and could actually strengthen Morrison's case for sanctions. Trump allegedly hung up on them. Meanwhile, legal observers and ethics experts are sounding alarms. The National Association of Criminal Defense Lawyers issued a statement expressing concern that judges using preliminary rulings to threaten attorney discipline before cases are fully litigated could have a chilling effect on vigorous advocacy. At the same time, the New York State Bar Association's Ethics Committee noted that attorneys have affirmative obligations to correct false statements made to tribunals, and that those obligations sometimes require withdrawing from representation if a client insists on maintaining false positions. Things escalated further when Trump responded via his Truth Social platform at 2:47 p.m. on Friday. He posted a series of messages calling Morrison a radical left activist judge who's part of the deep state conspiracy to destroy him. He claimed the preliminary ruling was written by Democrat operatives, not the judge. He attacked the 4 attorneys who withdrew, calling them plants who were always working for the other side, and claimed they left because they were about to be exposed as traitors. Legal experts flagged the danger in these statements immediately. Stay with me. What comes next will completely change how you view the situation. Here's what makes it even more extraordinary. Trump's own response to the attorney walkout essentially confirmed Judge Morrison's concerns about client control and frivolous litigation strategies. Instead of addressing the substantive findings in her 7-page ruling, instead of presenting evidence that his property valuations were actually defensible, Trump's reaction was to attack the judge's legitimacy and claim a vast conspiracy involving his own attorneys. And when your first response to a devastating legal ruling isn't to dispute the facts or law, but to claim persecution and attack everyone involved, including your own lawyers, you've essentially conceded you don't have a legitimate defense. Legal ethics experts immediately flagged how this creates an impossible situation for any attorney still representing Trump or considering doing so. Lisa Bloom, a civil rights attorney who has handled numerous high-profile cases, told CNN, "Look at what just happened." Experienced attorneys recognized the legal position was untenable and withdrew following their ethical obligations, and Trump's immediate reaction is to publicly attack them and call them traitors. What lawyer is going to step into that situation knowing that if they exercise their professional judgment to avoid sanctions, they'll be publicly savaged by their own client? This goes far beyond one case in one courtroom in Manhattan. It's about whether representation of controversial clients in cases involving substantial evidence of wrongdoing has become professionally impossible under current ethical enforcement standards. If federal judges can threaten disciplinary action based on preliminary assessments before the case is even fully litigated, it means attorneys have to make impossible predictions about how tribunals will view their arguments months, years down the line. That's not a standard any lawyer can reliably meet. But here's the counter-argument that legal ethics experts point to. The preliminary ruling didn't threaten sanctions for making aggressive legal arguments or creative interpretations of ambiguous facts. According to multiple attorneys who reviewed Morrison's 47 pages, she identified specific instances where Trump's legal team presented property valuations to the court that their own documents showed they knew were inflated. For example, the ruling reportedly details how Trump valued Mar-a-Lago at $739 million by claiming it could be developed and sold as residential properties, when Trump's own deed restrictions, which his attorneys had copies of, explicitly prohibited any use except as a single-family private club. That's not zealous advocacy of an uncertain position. That's allegedly presenting facts the lawyers knew were false. Once you're in that territory, every ethics rule says you must either correct the record or withdraw. If this blows your mind, hit that like button right now. Here's the situation. 11 attorneys have abandoned Trump's legal defense in 72 hours after a federal judge issued a preliminary ruling so critical that it threatened potential bar discipline against defense counsel. 4 of those attorneys walked out of an active court hearing while the judge was still speaking, rather than continue association with arguments the court had just labeled frivolous and potentially sanctionable. This is no longer just about whether Trump inflated property values or committed fraud. It's about whether he can find attorneys willing to defend him when doing so might cost them their professional licenses. When experienced litigators with decades of defending controversial clients suddenly flee mid-hearing, rather than continue representation, we've entered territory where attorney-client relationships break down under the weight of irreconcilable ethical conflicts. If there are no consequences for attorneys who knowingly present false information to courts, the judicial system cannot function because it depends entirely on attorney candor. But if judges can threaten lawyers with career destruction based on preliminary rulings before cases are fully heard, zealous advocacy for unpopular clients becomes professionally suicidal. Keep a close eye on this story. Judge Morrison has scheduled a hearing for January 26 to address the attorney withdrawals and determine whether the case can proceed to trial as scheduled. Trump has until January 24th to either retain new counsel or convince his former attorneys to return. Meanwhile, legal ethics experts are watching to see if Morrison actually follows through on her threat to refer the withdrawn attorneys to the disciplinary committee, or if that was simply a warning shot to force better conduct going forward. And attorneys across the country who handle high-stakes litigation are carefully studying Morrison's preliminary ruling to understand where courts are drawing the line between aggressive advocacy and sanctionable conduct. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. A federal judge has issued preliminary findings so devastating to Trump's legal position that 11 attorneys, including his entire senior defense team, abandoned the case rather than continue defending. Arguments the court labeled as potentially fraudulent. Trump now has 5 days to find replacement counsel willing to take on a case that comes pre-packaged with judicial warnings about ethical violations and professional discipline. Meanwhile, the 4 attorneys who walked out mid-hearing are reportedly consulting with ethics counsel about whether they need to make formal notifications to the Bar Association about why they withdrew, potentially creating a permanent record that could affect their ability to practice in federal court. This isn't just another legal setback that will fade from headlines after Trump appeals or delays. This is a fundamental breakdown in the attorney-client relationship captured on the record in open court with dozens of witnesses. What happens next could determine whether controversial defendants accused of financial fraud can obtain competent legal representation at all, or whether the ethical rules have finally created an environment where some clients have become legally untouchable because no attorney is willing to risk their career defending them. The evidence is out there in a 47-page judicial ruling that systematically dismantled every major defense argument. The warning has been issued to any attorney considering taking this case. Now we wait to see if Trump can find lawyers willing to gamble their professional futures on arguments a federal judge has already declared meritless. The stakes have never been higher for both Trump's legal situation and for the broader question of how far attorney ethical obligations extend when clients demand defenses that counsel believes are factually false. The attorney exodus has never been more dramatic or public, and the collision between zealous advocacy and attorney candor has never been more immediate or visible. Pause for a second and hit that like button if you're finding value in this coverage.